We see several gun rights groups filing amicus briefs for a petition to SCOTUS on the U.S. v. Harris case. The primary question here, should you have a class of people banned from being able to purchase firearms because they use marijuana? Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are finally broaching the marijuana question with firearm ownership. Obviously, a lot of you who have purchased firearms understand what the 4473 is and why, at least on a legal level, that's not possible. But we see a case go to the Supreme Court, that is U.S. v. Harris, to see if the justices there will take that up. And we filed an amicus brief on it. So to walk us through that, we have brought back CRPA's volunteer president. That, of course, is Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure, guys. Thank you for having me.
Absolutely. And guys, before we dive into this, please be sure to like, share, and subscribe to the videos. It really helps get the information out there. This has a lot more to do than just with something like marijuana. We are trying to protect rights as a whole, and by filing amicus briefs supporting some of these bills, we are hoping to do that on the federal level, which can then translate here into California. So, Chuck, can you just kind of walk us through, because this one on a surface level kind of has the firearms community split all by itself. I mean, not even considering everybody outside the firearms community, but the U.S. v. Harris case, can you go ahead and walk us through this? How did it become a case, and how did it get all the way up to the Supreme Court?
Well, okay. First, remember, you have to have this in context. Right now, there are 29 Second Amendment related cases either in the Supreme Court or asking the Supreme Court to accept them for review. Two of those cases have been accepted for review so far this term. One is the Walford case, which deals with the vampire rule in Hawaii. That's a sensitive places case. And one is the Hemani case, which is a cannabis case. And the question is whether or not that particular defendant can be convicted for possessing a firearm when he uses cannabis and apparently other drugs in that case too. Now, that particular defendant is not particularly attractive factually. He's got alleged terrorist ties and some other bad things about him that really, bad facts make bad law. We don't like cases with bad facts that make the justices inclined to not let the guy get away with it. So the Harris case so the Hemani case is about cannabis and whether or not, and other drugs, and whether or not you can be prohibited from possessing firearms by virtue of using them. The Harris case is also a cannabis case, much more benign facts. A gun was stolen from the defendant in that case. He did use marijuana, and when the police interviewed him about his stolen gun, he admitted that he was using marijuana, and so they prosecuted him for possession of a firearm while he was under the influence. He wasn't under the influence when he was using the firearm, but he possessed a firearm, he owned a firearm, and he used cannabis. So that's a much cleaner, more benign factual case that we want to support so that it kind of takes away from the bad facts in the Hemani case. So those are prohibited persons cases, and whether you like cannabis or not, or whether or not, however you feel about illegal drugs, the question is, under what circumstances can a class of people be prohibited from owning firearms? The answer to that should be when there is an individual finding of dangerousness, not because someone smokes a joint once in a while, or is a member of a particular race or a particular religion, or has a nonviolent criminal conviction, whether it's a misdemeanor or a felony. There's no indication of violence just by virtue of being in these classes. That's why these cases are important, not just about cannabis and firearms, but about what grounds the government can use to prohibit a class of people, not just an individual, a class of people from owning or possessing firearms and lose their Second Amendment rights by virtue of being in that class.
Yeah, and the logical conclusion simply has to be, if they can do it to one class, what's going to stop them in the future from doing it to perhaps a class that you belong to? So definitely worth some defense there. Guys, if you didn't know this, I learned something new when preparing for this video. There is a publication called The Marijuana Moment. Jacob, if you could pull this up, they wrote an article on this. Let's go ahead and see what it has to say. It reads like this. A coalition of gun rights organizations is urging the U.S. Supreme Court to expand its examination of the constitutionality of a federal ban on firearm ownership by people who use marijuana. Telling justices that a recent case on the issue is accepted would not properly settle the question of the current law's constitutionality. After the Supreme Court granted cert in the case U.S. v. Hemani earlier this month, which the Trump administration had pushed for, the Second Amendment Foundation and 5 other gun rights advocacy groups filed an amicus brief on Wednesday in a separate case pending before the justices. With the gun rights groups What the gun rights groups asked in their brief in the Harris case is that the Supreme Court jointly consider Hemani and Harris together to get a more comprehensive look at the constitutional challenge to the firearms ban known as 18 U.S.C. 922 G3. One of the main contentions with singular focus on Hemani, the brief says, is the fact that the case is not limited to marijuana. In addition to SAF, the brief was also joined by the California Rifle and Pistol Association, Second Amendment Law Center, Operation Blazing Sword, Pink Pistols, Minnesota Gun Owners Caucus, and Minnesota Gun Owners Law Center. Amid numerous legal challenges to the law as it applies to cannabis consumers, the Justice Department has consistently defined the prohibition, likening marijuana users to mentally ill people and those who are habitually intoxicated, for example. Some suspect the federal government's push for the justices to take up Hemani over the other cases is because the multiple drugs involved that could play in its favor. The new brief is also addressing a core question on whether the gun ban for marijuana users is historically analogous to the country's founding era. The DOJ making the case that because some laws prohibit people from possessing guns while drunk from alcohol, that's a sufficient standard to justify the marijuana and firearms ban. So I guess, Chuck, before we get, I alluded to this at the beginning of the video, before we get into some of these core questions, and in my opinion, a glaring issue with the way that the state is trying to argue this when they're talking about banning people who are publicly intoxicated. Can you walk us through how does the federal ban as it stands under this law actually play out when somebody is going to buy or purchase a firearm? How does this even come up?
One of the questions on the 4473 form, the federal form that you fill out is, are you a user of or addicted to marijuana? And so if you say no, but you are in fact a marijuana user, and it doesn't, not just addicted to, a user of illegal marijuana. Now, remember, it's always illegal under federal law. It's still illegal under federal law, even if it's legal in the state you're in. So that's a untrue statement, and that's a second offense that you can be charged with for falsely saying that you're not a user. Now, they get into spatial temporal questions like, well, I used it 10 days ago, I'm not using it right now. Nobody's saying that you should be able to have a gun on you when you're drunk, or have a gun on, or when you're high, or use a gun when you're drunk or high. And that's what that old law, you can imagine, of course, if they don't want people in historical times, the tradition was you could stop someone from possessing or shooting up a bar, when they're drunk. That's a far cry from saying that if you've ever used cannabis, or for that matter, you ever have a drink, that you now can't possess firearms at all. So, but that's what this government has been advocating. And we're a little confused by it, to tell you the truth, because I think it's the United States government asked the Supreme Court to take this case because this particular individual was so dangerous, implicitly so, and perhaps expressly so. I think he did some things that were very dangerous. So they want to make sure that they can prohibit him, but they're missing the benign person like Harris, who just had his gun stolen and answered some questions for police.
Right. So, I mean, simply put, when you go to buy a firearm, if you haven't done this already, you got to fill out a form. That form asks you a ton of questions, one of which is, do you use marijuana? This was actually part of the Hunter Biden allegations because there are people who lie on that form. They say the answer is no. They're able to purchase the firearm, and I think that's what you were talking about when you get more things put against you if you are found to be lying when you fill out that form to purchase a firearm. But then you kind of started digging into what I see as the core question from what I've seen from this case. Is the government conflating history and tradition within the United States? Is it conflating the laws on carrying a firearm and owning a firearm? Because from what I'm able to find just with a couple of quick searches are maybe some laws that are prohibiting people from possessing a firearm when intoxicated. I don't see any laws that ban people from owning firearms because there are times when they become intoxicated. Carrying and owning are two very different things. Is that what you kind of see as the main argument as we're going to the Supreme Court on this?
Well, in a sense, yes. I mean, you just because you have a drink once in a while doesn't mean you should not be able to own a firearm. Even it does mean that while you're in a bar drinking, you shouldn't be able to possess it at that time. And I don't know that anybody has. That's not squarely what the court is being asked. What the court's being asked about is just ownership. And the gun's at home and you're at the bar, but you own it. And so, are you breaking the law by just owning it at the house when if you're out someplace else getting drunk or smoking marijuana or whatever? Those are intertwined in the factual issues that the court's going to have to deal with. But the primary question is ownership and use, and not necessarily using while you're possessing.
Yeah, and I guess that's kind of why, to me at least, it seems like the state's argument or the government's arguments from the past don't really seem to hold up, because the old laws that they bring up, as per the Bruen decision, it seems like they're talking about possession. In any case,
they're talking about carrying when you're intoxicated, and that's another thing that this case could really help settle. What kind of historical analog law do you really need to have? You shouldn't be able to bootstrap. Oh, there's this law that says you can't carry a gun when you're drunk in some old Western town in a saloon, or in the Boston Commons, some of the pubs back then. That doesn't equate to you shouldn't be able to possess or own a firearm if you ever drink. So that's not really a historical analog. If the Supreme Court does nothing more than says that doesn't count, that kind of thing doesn't count, you can't stretch it that much, that would be helpful, because the games that we're up against in all these cases, and if you go to the gun case tracker on Airtable by Google, if you Google that, you'll see these 29 cases. There's several prohibited persons cases. There's the under 21-year-old prohibited persons. There's nonviolent felons. There's a couple different classes of prohibited person that the Supreme Court's being asked to look at, in addition to semi-autos, magazines, sensitive places. There's a number of different categories, all of which apply to CRPA's ongoing litigation. We have sensitive places cases. We have semi-auto ban challenges. We have the magazine challenge, which is Duncan, which is in the Supreme Court right now asking for review. We have the other challenges, the roster challenge, which bans a huge swath of all handguns from being sold. We have a dog in this fight, in all of these fights, because what the Supreme Court says will impact us here in California in the current litigation that CRPA is running. So we have to get involved, and we will be submitting, CRPA and the Second Amendment Law Center will be submitting briefs in many of the Supreme Court cases that are we're certainly going to submit them in the cases that have been accepted by the Supreme Court for review, but we're going to urge the court to take several more of these cases, in particular Duncan, which is our 7-year battle with California over standard capacity magazine possession. But the point is that any of these cases could answer questions about what is included under the first step, which is the language of the Second Amendment. What does it mean to keep and bear arms? What's an arm, and what auxiliary conduct is covered by the keep and bear arms, going to the shooting range, hunting, not just self-defense. And then the second question is there a traditional law? Is there a tradition of regulating in the way we're regulating today? Is there some historical analog law that indicates that the founders would have tolerated the modern day law? And if those historical laws are too attenuated, too removed from the modern day law, this is what the state's arguing. A Bowie knife, a law, possession or carry ban means you can ban the possession of semi-autos.
I think that context is actually really important because it's really easy sometimes to, reduce these efforts and these stances to kind of just a singular note of how can you look at a gun rights organization and see that they support law enforcement, but at the same time, they also support a marijuana user owning a firearm. It's because it's part of a larger theme. It's because rights are really larger than any individual idea like that. You're talking about, the government creating classes of prohibited people, which, this, like all the things that you stated, is not off theme from that. So there is a larger picture here. There is a larger reason. And those two things can exist in the same box of truth as we push forward here. I guess, Chuck, as we round this out, I'll give you a twofer. Timetable, I know I always ask this, and it's never like an exact thing. Do you see this perhaps getting taken up soon, since they already have taken the Hemani case with the argument of they should be done together? And also, if this is taken and if it goes the way that we would like it to go, what are the immediate ramifications? Does that question just immediately come off the 4473? What does success in a case like this look like?
Well, the 4473 would have to be revised because it's no longer a prohibiting category. But to answer your question, remember that you file a petition for review. It's a petition for a writ of certiorari. You're basically asking the Supreme Court to take the case. In the Harris case, all that's happened so far is that petition was filed, and there's been some amicus briefs filed, including by us, by CRPA. In the Himani case, that petition was filed, a response or opposition was filed, then their reply was filed, and then it got scheduled for a conference for the judges to vote on whether or not they're going to take the case, and they took it. So now the petition for certiorari has been granted. In Duncan, for example, we just filed the reply brief last week. So we filed our petition, the state opposed it, we filed our reply brief. Now it's been scheduled for a conference, so it's been distributed. If you look at this Airtable that shows where all these cases stand, it's been distributed for conference. There's going to be a vote, or at least they're going to start to think about it, on November 21st on the Duncan case. Now, they a lot of times they postpone it till the next week's conference, and the next week's conference they roll it on before they decide whether to take it or not. And that's what happened the last time Duncan was up there, because the Bruen case was pending. And so they just held it over. They kept meeting on it, but they said postpone it. And then finally, when Bruen came down, they granted cert, but rather than hearing it on the merits, they simply vacated the lower court decision and said, in light of what we just said in Bruen, reconsider your opinion. So that can happen too. That's called a grant, vacate, and remand, GVR. So it's all Supreme Court procedure, but some of these are in different stages. So the petition gets filed, the state files an opposition, there's a reply brief filed, there's a conference, and then there's a vote on whether to take the case or not. And if they take the case, then you open up the whole nother round of briefing on the merits of the case before the oral argument. CRPA is watching, and Second Amendment Law Center are watching all of these cases, keeping track of where they are in the process, and getting involved on behalf of CRPA members and all of our supporters and gun owners everywhere, frankly, to try and make sure that the record is complete, that all the arguments that can be made are made. Because remember, there's page limitations. Like, the parties in these cases only have a certain number of pages that they can use to make their argument. So the amicus briefs really supplement that and can get into sort of these tangential issues like, possession versus carrying, or possession while intoxicated versus, occasionally drinking or occasionally smoking marijuana. Those are the kinds of distinctions that sometimes can't get made in the primary briefs and have to be made in amicus briefs. So really, CRPA could use the support of its members. Again, whatever comes out of the Supreme Court applies all across the country. So it will affect us in California, even if, like, for example, that Harris case is out of Pennsylvania. It's still going to set the national precedent, legal precedent for what the law is about prohibited people and who can be one.
Well, needless to say, there is a little bit of separation here. I guess the way that you're making it sound, there would need to be some briefs filed, opposition briefs, response briefs, before SCOTUS would even put it on its consent calendar. Also very exciting, mark it, because, that sort of sets the watch party for Duncan on the 21st of November, did you say? So that's when we'll start there. Perhaps we'll have to do an update on that as that comes up, and then week after week, hopefully not week after week, but we will be watching out to see if they take Duncan. But there is a little bit of separation between Harris and Himani, so Harris has a little bit to go before it might even be considered. And hey, man, I don't know. The way that you're talking about this, it kind of seems like a rule needs to be made that if the Supreme Court grants certiorari and then vacates the decision, if that trend of decisions is the same the second time, maybe they should just take it. Or maybe I'm crazy.
No, you're not crazy. The Ninth Circuit is playing games. And many of the justices in the Ninth Circuit have called out their colleagues for playing those games. Because Bruen should have changed the decision in Duncan. But they twist it. They say, magazines aren't arms, so they're not even covered by the language of the Second Amendment. Well, they're indispensable, a part of an arm that, it's like saying you can ban the barrel, you can require a certain barrel, or ammunition that only goes so fast. I mean, if they can tinker with the magazine, then they can tinker with any part of a gun and make your gun, less effective, less useful, less designed for the purpose that you want to use it for, whether it's self-defense or hunting or whatever. They can water that down.
Well, maybe some progress to be had there, and big thanks to people who stand by the Constitution, like Judge Van Dyke. I know that he got a lot of attention with the Duncan case when he originally made that video, just kind of showing people what the ramifications of what they're saying about magazines is.
Every CRPA member should watch that video and see what the judges who get it sound like.
Needless to say, though, Chuck, I know you're a busy guy, and I can't wait to have you back, especially for Duncan. But thank you very much for coming on and sharing with us today. I appreciate it.
My pleasure, guys. And all the viewers out there, if you can help support CRPA, you'll be a part of history. This is a historic time for the Second Amendment as this area of law develops and gets locked in for future generations. So help us lock it in our favor.
Yes, I agree. Thank you very much, Chuck, and we will be seeing you soon. And guys, another way that you can help contribute to this effort is by liking, sharing, and subscribing to the videos. It really helps get the info out there as far and wide as it can possibly go. Let's keep pushing the two-way movement in the right direction, both with legislative efforts and with litigative efforts. The likes, the shares, and the subscribes really help with that. Thanks again, guys. We'll see you on the next one.